Let us start to solve the questions of Indian Evidence Act. First of all, we read the quotation that is written, ज़्यादातर लोग इसलिए सफल नहीं हो पाते क्योंकि वो दूसरों की बातों पर ज़्यादा ध्यान देते हैं। दूसरे की बात सुनेंगे मतलब अपना जो ओरिजिनल रूप है, हम जो विचार करते हैं अपना दिमाग नहीं लगाएंगे। The quotation says it. Yes, we start the question first. Confession of an accused is irrelevant and inadmissible when made. When such confession is made in the custody of police officer, but in the immediate, it means direct presence of a magistrate, such confession shall be relevant according to section 26. But here the question is asked, confession of an accused is irrelevant and inadmissible. So the A is not correct. Next, before a magistrate who told him that if he made a full confession, he would be released. It means the police officer told the accused, if you confessed your offense before the magistrate, you shall be released. Such statement was disclosed by the accused before the magistrate, so such confession before the magistrate also shall not be relevant. And according to the question, which confession of the accused is irrelevant, inadmissible, the such type of confession of the accused shall be irrelevant and inadmissible. So the option B is the correct answer. I read again. Before a magistrate who told him that if he made a full confession, he would be released, because if such type of statement is given, then such confession shall be irrelevant, because such confession was given under inducement. According to the section 24, if any confession is made under the inducement, promise, threat, such confession shall be irrelevant and inadmissible. So the correct answer of the question is B. Okay. Next, a retracted confession can be made solely the basis of conviction. A retracted confession can be made solely the basis of conviction. No, cannot be made solely the basis of conviction. Cannot be made solely the basis of conviction unless the same is corroborated. Yes, the correct answer shall be C, because a retracted confession must be corroborated by other evidences. Undoubtedly, on the basis of retracted confession, a person may be convicted, but other evidences corroborate it, then the court shall convict the accused as a offender. Okay, so the correct answer of the question C, cannot be made solely the basis of conviction. Other evidences are also required. The best answer of the question C. Next, the term judicial confession means. Judicial confession means it is made before a police officer. No. It is caused by inducement. No. It is made before any court officer. It is made before a magistrate. If any confession is made before the court, in the court, such confession shall be called judicial confession. What is court? Court is defined in the court term is defined in Indian Evidence Act, and according to the definition, a magistrate, all the magistrate judges except the arbitrators shall be called the court. It means magistrate is a court. Okay, so the correct answer of the question D. D is the correct answer of the question. Next question. Confession in criminal proceeding inconsistent. Inconsistent. The term is inconsistent. Confession in criminal proceeding inconsistent. When it is caused by inducement. Yes. When it is caused by threat or promise according to section 24. Both A and B. Yes. This is the correct answer. Because inconsistent confession in criminal proceeding, any confession in criminal proceedings shall be inconsistent when such confession is made under the inducement, threat or promise. According to section 24, such confession shall be irrelevant, inadmissible. So the correct answer of the question shall be C. Okay. A says to B that he has finished his wife forever. Under Indian Evidence Act, this statement amounts to confession. Yes. If a says that he finished his wife forever, it means he killed his wife. And if such statement is given without any fear, without any inducement, without any promise, such confession shall be relevant, admissible, and it is also such a statement shall be called confession according to the definition given by Atkin in the case Pakla Narayan Swamy versus Emperor 1939. If the accused confess his offense directly and the statement that is given not self-incriminatory, such a statement shall be called confession. This is the definition of the confession made by the Lord Atkin in the case Pakla Narayan Swamy. According to the definition given by the Lord Atkin, this is the confession. So the correct answer of the question shall be B. Shall be B. This is the correct answer. Yes. Next. Statement all admission are confession, no, false. But all confession are not admission, yes, wrong. Okay. All admissions are confession, no. All confession may be admission, but all admission may not be confession. You can say that confession is subset of the term admission. Subset. So correct answer A is false. Next question. Yes. Definition of a confession was given by the Privy Council in the case Pakla Narayan Swamy versus Emperor 1939 by Lord Atkin. So the correct answer C. Which of the following court passed the judgment in the case of Pakla Narayan Swamy versus Emperor? Which of the following court passed the judgment in the case of Pakla Narayan Swamy versus Emperor? Privy Council, Justice Lord Atkin decided the case. So the correct answer B. The case of Palvinder Kaur versus State of Punjab relates to which of the following? Yes, confession. Though it is also relating to dying declaration, but accurate answer according to the option shall be A, because confession is defined in the case by Lord Atkin. So direct relation of the case is to confession. So the correct answer of the question shall be A. In which of the following case the Supreme Court held that the court must accept confession? The court must accept confession as a whole and cannot accept only inculpatory and reject the exculpatory part of the statement. Court cannot do. This statement was given in the case of Palvinder Kaur versus State of Punjab. So the correct answer, Palvinder Kaur versus State of Punjab. In this case, Supreme Court said that court cannot accept the inculpatory part of the confession and reject the exculpatory part of the confession. Court must accept the whole statement that was given by the accused. If a part the court accepts and other part the court denies, it should not be committed. It should not be done by the court. The statement was given by the Supreme Court in the case Palvinder Kaur versus State of Punjab. So the correct answer of the question is A is prosecuted for the murder of B. A is prosecuted for the murder of B. A confessed to the crime before the police officer and not done then. The term is then. And then told the magistrate, I told the police officer that I had killed B. This statement is inadmissible, not admissible. Why? A is prosecuted for the murder of B. Yes, A confessed to the crime before the police officer. When A confessed his offense before the police officer and then he told before the magistrate, okay, I told the police officer that I had killed B earlier before the police officer. So such a statement that was made before the police officer shall be irrelevant, inadmissible. This statement is inadmissible, irrelevant. So the correct answer of the question shall be A. A confession made to police officer will not be proved. Will not be proved. Okay? To be considered confession. No, not considered to be confession made to police officer will not be proved. So, person making the statement, making the confession before the police officer shall not be used as and shall not be produced as an evidence in the court against the person. So, the correct answer of the question B. Confessions made while in custody of police are irrelevant. Yes. Inadmissible. Irrelevant confession made while in custody of police shall be irrelevant, inadmissible if any statement is given. If any statement is given if any statement is given before the police officer or any confession made to police officer shall be irrelevant. So the correct answer of the question A, according to the option. A relevant confession will become irrelevant when made to police officer. Yes, made under a promise of secrecy according to section 29, it shall be relevant. It shall be relevant. So, made to a police officer clearly according to section 25, such statement, such confession shall be irrelevant. The correct answer of the question 14A. Whether confession made to police officer while not in custody by a person accused of an offense can be proved against him and is evidence and is an evidence. What type of evidence? Admissible or not admissible? If the person is not in the custody of police officer, but confession made to police officer, what does it mean? It means a confession made to the police officer under section 25, any confession made to police officer shall be irrelevant. So the irrelevant, not admissible. So the correct answer of the question shall be not admissible. The correct answer of B. Correct answer of the question B. When a confession otherwise relevant will become irrelevant. Otherwise relevant, it means the confession is otherwise relevant, shall be irrelevant when the confession made to police officer. Yes, the question is repeated. Question number 16, question number 15. Question number 15. Yes, I have told you, of an offense can be proved against him and is an evidence not admissible. Yes, like that. Not the same question, but like that. Similar question. When a confession otherwise relevant will become irrelevant if made to police officer. Yes, by the accused under section 25 of the Indian Evidence Act 1872 before the following persons section made is not admissible. Not admissible if any confession is made before the following these person, when the confession shall not be relevant. Home Minister, wife of DGP, Director General of Police, Sarpanch of Village, Superintendent of Police. According to the option, if we see the option of the question, if we see the option of the question, the correct answer of the question shall be D, Superintendent of Police. It means ESP. Any offense, any confession, if any confession made, any confession made to police officer shall not be admissible, shall not be relevant. So the correct answer of the question D. D shall be the correct answer. Confession made by a person. Confession made by a person in police custody shall not be proved as against such person under which section of the Evidence Act. Confession made by a person in police custody. Police custody. Any confession made to police officer. Any confession made by a person who is in the custody of police officer shall be irrelevant, inadmissible according to the section 26 of Indian Evidence Act. So the correct answer of the question shall be B. B shall be the correct answer of the question. Okay? Yes. Question number 19. A confession made to the judicial magistrate. A confession made to the judicial magistrate are relevant. Which provision of the Evidence Act? It means which section says it? If any statement produced before the judicial magistrate shall be relevant. If you see the last line, last line of the section 26, accused made confession in the custody of police officer shall be irrelevant, but it shall be relevant when immediate presence of the magistrate. If it is made immediate presence of the magistrate, then such confession shall be relevant, admissible also. So the correct answer of the question shall be 26. 26 is the correct answer of the question 19. A confession made by any person while in the police custody will be relevant if it has been made immediately in the presence of magistrate, according to section 26. According 26, first of all, we study all option. A confession made by any person while in police custody will be relevant if it has been made immediately in the presence of magistrate. Yes, according to the section 26, it is the correct answer. Immediately in the presence of superintendent of police. No. Immediately in the presence of, no. The correct answer of the question shall be A. A is the correct answer. Yes. Thank you. That's all okay.